I'm laying on the floor waiting to die.
Man, that must be really unergonomic for recording a podcast.
That might be why your sound isn't as good as AJ's, Tom.
Guys, I have to tell you something really important.
Talk to us, dude.
Lily and I were very sick on Friday, and I'm still a little sick.
Dude, this means I have a chance at not sounding the worst.
I'm starting to record.
There was a moment on Friday. Oh, I've been recording. Hey, Tom. I really think that's going to be like a service to our listeners. But they like take a moment to find the breath and sort of become within themselves. I think that'll be useful.
Instead of podcasting, maybe we can go into the business of making soothing sounds for our listeners to go to sleep at.
Oh, Tom, I've got one of those. Are you ready?
And we could charge for that. Tom, you're supposed to go after I am. Like AJ starts, then I say Om, then you say Om, and then we just repeat that for an hour.
I'm the least Indian person here.
Anybody have any follow-up?
AJ, you had that case about the missing comma?
That's not really follow-up. All right. We don't have any follow-up. There's no follow-up.
You put it in the show notes under follow-up, so...
No, I put it in the show notes under around the news.
But then you didn't bold that, dude.
Yeah, you didn't tag it as the appropriate heading level.
Oh.
There. So we have no follow-up.
I'm given to understand that there's no follow-up. Ruchit's no longer in... we got follow-up. Ruchit's not in India. They kicked him out.
I think the bigger news is that he's back in the United States and they didn't kick him out or keep him out.
A spokesman for Narendra Modi has announced that India's long-suffering Ruchit problem is over. Ruchit has left India.
And then I was in Denmark, and then I was in Canada, and I'm convinced that the reason I got in so easily is because our border security at the Canadian border is lax. There being no wall.
Are you kidding, Rich? Don't you remember our visit to Vancouver?
Yeah, dude, but it was a lot easier.
No,
man.
remember,
I just I did.
When we drove from Washington to Vancouver, they just waved us through. When we drove from Vancouver back to Washington, like they basically like searched our entire car. Held Arpin in a interrogation room for a couple of hours.
We were 4 brown guys in a car, and that was before Donald Trump was president.
Yeah, that's true.
Okay. Around the news, we've got interesting case I found. Hat tip to friend of the show, Twitter user @Paritsky. Good luck spelling it. He sent me this article for there's a first court of appeals case that begins, "For want of a comma, we have a case." I thought this was hilarious. Basically, the state of Maine, their statute drafting manual, their style guide, says not to use serial commas unless a serial comma is necessary to avoid ambiguity. They had an overtime statute. They had in the overtime pay statute, there was a list of exceptions, and the list of exceptions, because it's a list and the drafting manual says not to include a serial comma, didn't have a comma at the end, and it created a sort of eat, shoots, and leaves situation. And the court said that the lack of a comma created ambiguity, and they had to apply a broad reading of the statute, and now there's some shipping company somewhere in Maine that owes millions of dollars of back pay to some of their employees. And so my question is, if the Maine drafting manual acknowledges that a lack of serial commas can sometimes cause ambiguity, why wouldn't the Maine drafting manual just say, why don't we just use a little serial comma?
Because I think you have the opposite situation, right? If the Maine drafting manual were to say always use serial commas, or use serial commas to avoid ambiguity, I bet these legislators or the folks that write these bills, the lobbyists that write these bills, couldn't tell an Oxford comma from a, colon. Honestly, like what you end up having is another case somewhere out there about some chicken farmer who has some regulation that's applied to him, and it seems like the regulation shouldn't have an Oxford comma, but it instead does have.
And he doesn't have a Scott Pruitt to defend him.
It's true.
And his rights.
The drafting manual acknowledges that serial commas may sometimes be necessary to avoid ambiguity.
Yeah, my point is that it's not the fault of the drafting manual. I mean, that's a good statement. Like, I don't have any problem with the statement that you should use, if that's your preference, you don't want to use serial commas unless there's an ambiguity. Yeah, that can be your preference. Another preference might be, you should use serial commas always or whenever they're necessary, right?
Yeah, that's what I think. I think you should use serial commas.
Yeah.
Tom?
Yeah, but unless, they don't need to be a serial comma, you know what I mean? Like if you're literally saying my parents, Valsala and Jacob, right, you wouldn't use a serial comma there.
But that's not a list.
I know, but what I'm saying is that what you'll end up having if you say always use serial comma is some lobbyist is going to have a phrase like that, right? And insert a comma where that shouldn't be there. And then you have the opposite ambiguity problem,
So let me offer two alternative explanations for this. And first let me defend the people that draft bills.
Before you jump in, should we explain the Oxford comma? Is that common knowledge?
Everyone knows when it...
No, please.
We'll put the wiki in the show notes. Go to the show notes. Okay. The name of the case is O'Connor versus some dairy farm, and there'll be a link to the case in the show notes. There'll be a link to wiki in the show notes. Go to the show notes. Heartlanded.com. Go to the show notes.
This is a good way for us to promote ourselves, is to constantly say, no, we're not going to talk about this. Go to the show notes, heartlanded.com. Tell your friends, heartlanded.com.
Heartlanded.com. My Twitter handle is @AJSmull. Go to the show notes.
Maybe what we need to do is a dedicated episode on the Oxford versus the serial comma.
They're the same thing.
And it's the same. They're the same.
Oh, see,
Oxford and they're the same.
See, you see what I'm saying here in terms of we should probably explain this. Here I am, not understanding the difference, but I think I use it correctly. But the drafters are typically pretty good, at least in Texas. Our drafters are pretty awesome, like the attorneys that draft this stuff. But the other thing might be, too, that they wanted this ambiguity to help the legislation pass, because that's an underappreciated thing, right? Is a lot of times ambiguity helps you if you want to pass legislation. It's not good for clarity. It creates interesting court cases, but it does get bills passed.
For our listeners, Richard is probably drawing on his vast experience working at the Texas state legislature on this point, so I'd probably believe him.
Yeah. Thanks, guys. The people that are drafting these bills, like the legislative staff attorneys that will draft this stuff, I mean, they are top notch. And I guess I find it hard to believe that they made this mistake, because they're typically extremely deliberate about such things. And I wouldn't be surprised if it was like changed at the last minute, maybe by a lobbyist, or maybe it was just part of a compromise. And you never know when this stuff is going to impact.
Breaking. The wiki article also says that serial commas can create ambiguity. So basically, life is brutish and short, and we're all gonna die, and there's no helping
that was
ourselves.
my point earlier, right? Like that.
I didn't agree with your point, but now I agree with your point.
Well, I'm glad Wiki convinced you.
I think our listeners should know that AJ is sick, and hence his discussion on life being brutish short, and we're all going to die.
I'm dying. I'm so sick. I was much more sick on Friday.
And we're living in a Trump presidency. So our lives may indeed be brutish and short.
What else do we got? What else is around the news? The second Muslim ban has been halted by a Hawaii federal judge.
This is more of the same with regard to the courts enjoining Trump's executive order on preventing refugees from entering the United States. I thought actually the more interesting part of this story is all of the right-wing news sites who have cropped up and are asking the tough questions as to why is former President Barack Obama, a native of Hawaii, visiting Hawaii around the same time this Hawaiian judge issues a order halting the Muslim ban. These are tough questions. Do you guys have any answers?
I do. It's obviously a vast conspiracy, but I think the other conspiracy that people haven't been talking about enough is the law school class that produced Neil Gorsuch also produced Barack Obama and this judge. How about that?
Wow.
Mm-hmm. Maybe we should not confirm Neil Gorsuch on that grounds.
He is horribly intertwined. I mean, he went to law school with Barack Obama. If you voluntarily sat through law school with Barack Obama, doesn't that make you a pretty big liberal?
Or a Muslim?
I have a question. Was Gorsuch on the Harvard Law Review?
Ooh, that is a good question. That would mean Obama...
Follow up. Did he vote for Barack Obama for president?
Ask. I wonder if he did.
Of the Law Review or of the United States? Or both?
Yeah, Rujit. That's why we need serial commas.
Of the Law Review. You know, Barack Obama was the first African-American president of the Harvard Law Review?
Yeah, that's true. Probably. I mean,
no,
probably.
it is true.
Probably. I mean, I don't know.
But the question AJ raises is an important question someone should ask during his confirmation hearing. Did he vote for Barack Obama to be president of the Harvard Law Review?
Or of the country?
Was he on the Harvard Law Review?
So the thing about this Hawaii order that actually really stands out to me is how it quotes extensively in Trump's own words how the second Muslim ban is the same as the first Muslim ban to the extent that it offends the Constitution. In Nashville, Donald Trump called the second executive order a watered down version of the first executive order in a way that sort of, I'm sure there's some person in the Office of Legal Counsel somewhere who's just his face is so dug into his palm. There's a little trough in his palm where his face keeps hitting his palm. Like, cut this metaphor out.
Even Stephen Miller, the president's senior advisor, said that as well. You know, he said fundamentally, you're still going to have the same basic policy outcome. And, with the second executive order, which is, I guess there's kudos for just admitting it straight up. Makes it easy.
I can't wait for like 30 years from now when Stephen Miller tries to convince people that actually he was working to undermine Trumpism from the inside. Like the entire time he was writing those wackadoodle newsletters for Jeff Sessions, it was actually to discredit Sessions, as like the whole thing is an episode of The Producers Gone Awry. Like Stephen Miller's whole career, it was actually just springtime for Hitler in Germany.
Guys, I found out that he was not even on the Harvard Law Review.
Hold on a second.
Neil Gorsuch was not on the Harvard Law Review.
We are going to nominate someone to the Supreme Court who went to Harvard but was not good enough to be on the Law Review.
I can't believe that Neil Gorsuch would turn down an invitation from the Harvard Law Review just so that he wouldn't have to vote for Obama to be the president of the United States of America.
That's probably what it was.
What if he never got an invitation, guys?
No, of course he did.
Oh, that's even worse.
So, according to Harvard's website, while a student at Harvard Law School, he was editor of the Harvard Journal of Law and Public Policy.
That's the conservative version of the Law Review, Tom. And by that, I mean it's a conservative journal that may or may not be anywhere near as good as the Law Review.
At Texas, the conservative journal is called TROLP. Do you remember that, Richard?
No, it's not TROLP. That's the Texas Review of Litigation.
No, the Texas Review of Law and Politics.
TROLP. But honestly, I am now officially withdrawing my support for Neil Gorsuch, knowing that he couldn't even make it onto the law review. I mean, that means he's basically no different than me, another person who didn't make it onto the law review.
Basically.
Man. Wow, that like really puts a lot into perspective, you know? It just, you know.
For our listeners, AJ is going to do this from time to time. And it won't necessarily be to fill up time. It'll be more so to help you get peace, you know, which is a new goal of our show.
I want to help you find the bodhisattva that lives inside of yourself.
AJ is like my cab driver in Mumbai, who was always telling me to be at peace while he was getting me lost.
Did you have any Thomas Friedman moments?
Oh, come on. I have nothing but Thomas Friedman moments. I had those everywhere. In fact, let's add a new segment to the show.
Did you grow a mustache?
I did not. But let's add a new segment here on the fly. The Thomas Friedman moments that I had.
Everything Richard learned in the back of a cab in Dubai. Not in Dubai, in Mumbai.
In Mumbai, Copenhagen, and Miami. So let me start with Mumbai. The cab drivers and the Uber drivers all agree that Uber is not paying enough and is taking advantage of Uber drivers. So there's that. Second,
isn't that true everywhere?
Some things are universal, Tom. In this world where people are trying to tear us apart, there's some things that are universal. Another thing that I learned in the back of cabs.
Are you still Ubering? I thought we all agreed not to Uber anymore. Lyft?
Oh, I didn't agree to do that. I also had to Uber in Mumbai because
Richard, you can't tell our listeners that you Uber.
Like, have you read all of these stories about Uber, the internal goings on about?
Uber got sued by Google for trade secret violations, and that for me was the final straw.
That was your Neil Gorsuch wasn't on the law review moment.
Well, there was also the sexism.
Oh yeah, the sexism was my final straw.
Ruch, did you read that story?
I had no choice, guys. I did read that story.
It was appalling.
It was. I used Lyft for when I can, but in Mumbai, there's no Lyft.
Isn't there like just regular like rickshaws?
Yeah, dude, but like, I need someone to like get me now to go from like point A to point B. You know what I mean? And I could use cabs, but the problem is the cabbies refuse to use like Google Maps. So you tell them, and the thing is, so for people that have never been to India, there aren't fixed addresses in India everywhere. There's like so-and-so place near the water tower.
Or like someone's house name.
Like that's actually a way of, I'm not kidding. Like that's a way of addressing things.
Like it'll be like it's like the House of Shaw will be an address.
Yeah. Right, but even better, the house next to the House of Shaw, or the house behind the House of Shaw.
I guess those houses were not prominent enough to get their own name.
That's right. So my taxi driver, the only taxi that I really took, this guy couldn't figure out where we were going. And so I get into the car, me and Steph is my wife, and we are, I tell him where to go, and I'm speaking in Hindi, and, you know, my Hindi's not fantastic, but it's pretty good. And so he asks me, and I get in the car, we're talking in Hindi for 2 or 3 minutes, and he goes, "Where are you from?" And I say, "Gujarat," which is a state in India. And he says, no, where are you from?
Dude, that's like Indian people in America. When you tell them you're from Dallas, they're like, no, where are you really from?
Where do we send you after the squad picks you up?
I know, but I was in India, and this guy refused to... to believe that I was like from India. And so he asks me again, no, where are you from? And I say, listen, dude, I'm from Gujarat. And so he kind of gets frustrated with me, and he points to Steph and says in Hindi, "Where's she from?" And I say, "Gujarat." And at that point, I think our relationship changed. Me and the cab driver, that is. But other learnings, Thomas Friedman learnings. I did an informal poll of my buddies in my small town in Gujarat on whether demonetization was impacting them. And my buddies that run the electronics store in town said no. My buddies that run the men's and women's clothing stores in town said yes. So that was another learning.
Well, how is it affecting them?
Well, just the volume had gone down. Volume of business in like lighting and like panels and like things like that had not changed, but the volumes in
But think about how much cheaper the steel is from Asia. Like, don't your people in the tailoring industry appreciate how affordable steel is now?
Yeah, I don't know. They may not be thinking about that, but everybody has an opinion on stuff, which is pretty cool. And many of them are well informed. They all think Trump is an idiot, so that was not surprising at all. And then I went to Copenhagen, and there I had a Filipino, taxi driver, Filipino taxi driver. He had lived in Denmark for 20 years, and he was a little sad at how Denmark had been changing. He said that it was like a lot more open to immigrants 20 years ago when he came. And that was kind of he was just kind of, sad about that, I guess you could say. And he also very politely called their president ignorant. Then in Miami...
How politely are we talking here?
Very politely. Very politely. Kind of like... He was almost like hesitant to even like say the word the president of the United States or President Trump or whatever else. And even when I started bashing Trump, he was, he pretty hesitant to do so still. But eventually he was like, yeah, we're all immigrants here. And, although not so true in Denmark, but he is an immigrant for sure. But he said he was really glad that he got Danish citizenship because he's like, I don't think I could get it today.
Rich, your cursor is dancing all over the Google Doc.
Yeah, I'm doing that. I think it's like maybe it's a nervous twitch. Maybe, AJ, can you hit me with an ohm?
What do you know? Okay, Rich, you put a lot in this Google Doc. What do you want to say from this Google Doc? You wrote a lot of words.
I did.
How many of the words are good?
Well, that's for our audience to decide, not for me or you.
People. Are we going on to regulations that the Trump administration has decided to remove from our collective consciousness?
Indeed. So I thought it would be helpful. The Trump administration has been in office for 8 weeks, and I thought before we even get to the regulation, it might be good to do a just quick rundown of the things they've done in 8 weeks. So 2 unconstitutional Muslim bans.
Well, hold on. To be fair, it's not that the courts held those bans to be unconstitutional. It's that there was a high likelihood of success. I mean, it's a...
yes, you're right, because they were
temporary injunctions or preliminary injunctions. So, the courts were saying our best guesstimation is that these bans are unconstitutional.
That's a good point.
That's the kind of hair splitting that people tune in for.
That's why they're listening to us and not Chris Matthews, AJ.
All right, so those are just the regulations that Trump has propounded.
Yes.
What do we got in the rescinding area?
So even before I get to that, AJ, we now have a long list of countries that we used to be strong allies with that now we need to rethink. The United Kingdom, Germany, Australia, Sweden.
Yucko. Ugh.
Who needs allies? Who needs friends? Said everyone in all aspects of life. And Trump has attacked the judiciary. He's accused the former president of wiretapping him without any facts. And if all of those things weren't enough, he's also proposed. He's changed or eliminated over 90 regulations. So that's where we are. And I think most people don't know that is happening right now, and that's why I thought we would talk about it.
Yeah, but before we do, one of my favorite Twitters is the Crime a Day Twitter. Do you guys know about that?
No.
So the crime a day Twitter is just it just tweets out a crime that one of these federal regulations or federal statutes makes illegal. I can give you some examples real quick. 21 USC section 333, 343, and 21 CFR 10241 make it a federal crime to sell potato chips made from dried potatoes without saying so on the label. It's a federal crime to import a giraffe without a permit.
Tom, I feel like you're making the argument that there are lots of regulations that should be rid of.
It's a federal crime to abandon a plant at the National Arboretum.
They probably just don't want you, like, you know, throwing your shit at the National Arboretum. You think that, like, it's a recycling area for plants, and so you're like, oh yeah, National Arboretum, I have a dead plant, I'll take it there.
Could be a live plant. Rescue plants.
But just think about those poor people out there who have adopted this plant and it's grown beyond their capacity to care for it, and their children have said, oh, I'll feed the plant and I'll clean up after the plant and I'll take care of this ficus or this chia pet or whatever the case may be. And there's this suburban homemaker out there, and he or she is at his or her wit's end, and they don't know what to do with this plant that has taken over their lives, and it consumes the food in their home, and it's the detritus that it leaves behind consumes their space. And you think to yourself, here is a place, this arboretum, this place that cares for the plants. We need to get this plant out of the house. My children need to live and breathe again. And you take it there, and now you're a federal criminal.
It's a federal crime to defecate in a reading room of the Library of Congress.
I don't know what I like better, AJ's or the fact that that's a federal crime. But President Trump didn't decide to work on any of these regulations. Instead, he worked on a whole bunch of other ones that were sought out by industry.
Can I just say before you go on? I'm sorry to keep interrupting, Ruchit, but I think it's a good law. I think it's a good law that prevents defecating, urinating, spitting, or other disruptive activities in the reading rooms of the Library of Congress. I want to be on the record. We should not repeal that law.
But does it need to be a federal crime? Do you need to go to federal prison for that?
If you have to repeal 2 regulations for every new regulation propounded, the no defecating at the library regulation is like gonna be one of the ones to go, because
I guess this is another one of those things where it's probably a big issue, and you don't want to turn this.
All right, Ruch.
Yeah.
The Republicans have eliminated over 90 regulations.
Yeah. Oh, yeah. So just to give you some examples, and the New York Times actually has done some good coverage on this, and I thought we'd bring attention to that. But so to give you some examples of things, the FCC has moved to repeal a rule on broadband privacy that would require these Verizon and Comcast and other broadband companies to use best efforts to make sure that your information does not get stolen. So, identity theft. Then there have been rules on drinking water that the farming industry has opposed. There's the Department of Labor rule that protects investors by creating a fiduciary standard for your financial advisor that President Trump has decided to revoke. There are rules regulating the disclosure of bribes to foreign governments that ExxonMobil and others have opposed, and Congress has repealed that rule. There's a rule on gun control. I mean, I'm just going on and on and on, but that's because there's 90 of these rules, and I'm not going to list all of them, but these are examples of the leashes coming off as I think the Trump administration themselves has said.
Are there particular rules you want to focus on and talk about?
Yeah. Yeah, let's talk about the stream rule. So the stream rule was put into effect by the Obama administration's Office of Surface Mining Reclamation and Enforcement. It's part of the Department of Interior. And they put this rule into place in December 2017 after, I think, close to 8 years of deliberating on this rule. And so just to take a step backwards, when an agency, and AJ, you may want to intervene here as you are an actual regulatory lawyer, but when an agency proposes a rule, they have to allow the public to comment. And so the public, of course, includes the people being regulated, like coal mining companies in this instance. And it's through that process of public comment that agencies refine rules. And they decide what is good, what is bad. And based on that, hopefully, they release a final rule. And that's what that multi-year process for the stream rule took. AJ, did I describe kind of that process accurately in terms of just sort of how the regulatory lawmaking works?
Yeah, so there's something called the Federal Administrative Procedures Act, and it sets out requirements for how agencies can adopt rules. So basically, Congress will delegate to, say, the Department of the Interior, hey, figure out what to do with streams. But they also have these procedures that are encoded in statute that say how to figure out what to do with streams. And my personal experience as a regulatory lawyer is that the comments that are provided by stakeholders, and they can come from industry, and the comments can come from customer groups, and the comments can just come from individuals, and they genuinely do influence the deliberations in rulemakings in ways that are meaningful, and I think sort of a good thing about our country.
Yeah, it gives everybody an opportunity that's paying attention to these rules, of course. And typically there are public interest groups that are representing the public interest, as you might think. And then you have industry, which are representing the interests of the industry. And that's a totally normal and reasonable thing for both those groups to be involved and to put their best case forward for why a rule should do what it does and in the ways that it does it.
So this rule, the stream rule that took 8 years to put together, what did it do? Like, what did it regulate?
So what it regulated is what a company that wants to open a surface or underground mine, basically what it can do and what research it needs to do and what it needs to do to avoid causing damage to waterways. So typically when a company gets a permit, so they could get a permit to mine, they could get a permit to release water into streams, they could get a permit to release pollution into the air, they get there's a limited area in which their permit applies. But obviously, when it comes to water, if you're dumping waste into rivers, for example, that's going to impact things outside of the area in which you got the permit. And that's what this rule does, is it goes into some excruciating detail about things like hydrological balance of waterways. But it's basically a stricter limit on what type of waste and debris you can dump when you coal mine. So when you blast off the side of a mountain in order to surface mine, or when you do underground mining, all that waste that's created in finding the ore or the coal or whatever else, or in mining that coal, where does that have to go? And can you just dump it in the water?
So before this rule, you could dump it into the water?
I think even after this rule, you can dump it into the water. It just changes like what you can do. And for example, the companies and the regulators have to do a baseline assessment of what a nearby like ecosystem looks like before they do new mining. Then they have to monitor affected streams, and they have to develop a plan for restoring those waterways to something close to their natural state after the mining is done. So that's one of the sort of crazy things, is this rule didn't even say you can't dump water. It just said if you're going to dump water into a riverway, you need to restore it. And you need to monitor what your dumping, waste is actually doing to those streams and to the animals and the plants and the communities around that stream.
So it's sort of like that rule that we tell children, leave a place better than you found it.
Yeah, it's exactly like that rule. A much more detailed version of that rule, but yeah, that's exactly what it is.
So now that rule is off the books?
Yeah, that rule's off the books. Yeah. So the way so just to be clear, when you often hear the president and Republicans talking about how when you eliminate these rules, when you deregulate, you create jobs, right? Or they say that regulations kill jobs. So according to the Office of Surface Mining Reclamation and Enforcement, this rule would have impacted a grand total of 124 jobs.
Well, according to the agency analysis, to be fair.
Yes, according to the analysis that they did, yeah. It's not a whole lot of jobs that are impacted by preventing companies from just sort of dumping at will into streams. And that's kind of the point here, is that there's a lot of rules like this that regulatory agencies enact because, let's face it, most people are not going to get out of bed thinking about whether or not their water should be clean. They're just going to assume it's clean. And that's kind of the environmental bargain that Americans have had since at least the 1970s.
Something that has seemed interesting to me is that there actually was a stream rule that was adopted by the Reagan administration in the Reagan Department of the Interior, and then in 2008, the Bush administration adopted an update to the stream rule, and the Obama DOJ supported litigation that sought to invalidate the stream rule. And meanwhile, while the DOJ was supporting that litigation, the Obama Department of the Interior was working on its own stream rule, and now Trump has rescinded the Obama stream rule. So is this just another one of those areas that has become totally partisan, that the Obama DOJ hates whatever Bush did and the Trump administration hates whatever the Obama Interior did? I mean, is this one of those things, or is something else happening?
I think it would be very easy to paint it as that's all that is happening is, hey, administrations change, elections have consequences. And I think the difference is that this rule, and I'm obviously in favor of this rule, and I'm generally in favor of environmental regulation, but this rule doesn't do very much harm. And even the Obama administration, there were lots of rules that they didn't enact or got substantially changed because they were doing cost-benefit analyses. So clearly some of the environmental groups didn't think that this rule went far enough, and they said so in comments, right? So I don't think it's something as simple as that. The other thing is, this was a rule that took 8 years to develop, right? And everybody had the opportunity to comment. And then, the policy or the regulators made a call effectively. And that was reversed in basically no time.
So maybe AJ or someone could explain to me the process of removing a rule from the books like this. I would have thought that there would be more required if you need to go through a notice and process comment to enact a rule. Is there no similar process to take a rule off the books, or can you just hit the delete key?
There's something called the Congressional Review Act. And what this does, it allows the House and the Senate to nullify any recently finalized federal regulation by a simple majority vote in both chambers. So, Tom, to answer your question, that's the mechanism that was used. And now there's some I don't know if there's any litigation yet, but there probably will be litigation on what recently enacted means. But, this one was enacted in December 2016. So I think under anybody's definition of recent, it's probably good enough.
Oh, okay. So here's the deal. According to Wikipedia, the Congressional Review Act says that Congress can pass a joint resolution of the House and the Senate disapproving of a agency rule. The time period in which that happens is 60 legislative days, i.e. days that the U.S. Congress is actually in session after the promulgation of the rule. So the key here is that this would be a check of in a situation where both houses of Congress come from a party that is not the president's party. This would be a check on the president's power, and then further, this would be a check on sort of midnight regulations that are passed by a lame duck president's administration as new majorities take office in Congress in the following January.
No, I think that's how it works. But I think the key importance is the number of legislative days, not 60 days period, right? So theoretically, a Republican Congress with a Democratic president could basically just not have a lot of legislative days. They could just not be in session. And in fact, Congress is in session less and less. I think.
Well, they did that, right? Wasn't that what the NLRB thing was about? That they kept like having little mini sessions here and there so that there wasn't an opportunity for a recess appointment?
Yeah, I think both parties have done something like that. They've both done that. And then I think, both parties have also, I think President Bush made appointments that were recess appointments where he was just sort of rolling the appointment because Congress refused to approve his appointments. So that's the Congressional Review Act, and that's this piece of legislation. Should we talk about the fiduciary rule, another important one, or we can go on to the next?
So what's the big takeaway? Like, let's do the fiduciary rule. Let's talk about the fiduciary rule, and then let's talk about like, what's the big takeaway? Why do I care?
Yeah. So the fiduciary rule is something that the Obama administration put into place last year. I forget when it was, but it was I think it was last summer, actually. It was the summer of 2016. And so right now, the vast majority of Americans get their retirement advice if they get retirement advice, they get it from financial advisors. And what I think most people would be surprised to know is financial advisors do not have a duty to ask or to act in the best interest of their clients. This is before the fiduciary rule. They also don't have a duty to disclose conflicts of interest, including the commissions they get for selling their products. So, this has happened. I mean, I think at length, where people will get recommended a product that is higher fee than a cheaper one because the financial advisor gets a higher commission from the higher fee product. I'm not saying all financial advisors do this, but certainly quite a few of them do. And I mean, I've had that experience, not personally, but with my dad, where he had somebody try and sell him a bunch of products that were really high fee and didn't disclose that the fact that they were making a commission. And what the Trump administration's Department of Labor did is, or rather, President Trump told his Department of Labor to revisit this regulation, which I think is going to be a very polite way of killing the fiduciary rule. I looked pretty extensively. I went and I read all the arguments, or not all, but at least as many as I could, in terms of comments submitted by the financial advisors, and I honestly couldn't find a good reason why they shouldn't be required to act in the best interest of their clients. It made no sense to me.
Let me ask you, would that rule have affected robo-advisors?
Yeah, it would have, absolutely. And the robo-advisors were actually in favor of it. So if you I actually read some blog posts posted by Betterment, which is a robo-advisor that should sponsor the show, frankly. But same could be said of Wealthfront, another robo-advisor that should also sponsor the show. And both of them had that. They both posted about how they welcome this fiduciary rule.
So why were the robo-advisors in favor of this fiduciary rule, but the real people advisors were not?
Because the robo-advisors, at least right now, all they sell is access to ETFs, and those ETFs are already extremely low fee, and they disclose how much money they make, and I think they see this as a marketing benefit to be in favor of this regulation effectively.
I guess for them it's probably easy to comply with it, huh?
Extremely easy, because they don't sell any financial products where they get a commission, right? They charge a flat fee to their clients, and that's it. I mean, or 0.25%, like a percentage fee. They don't get commissions from any of the companies whose products they sell.
Would this rule allow individuals to sue their advisors for breach of fiduciary duty?
Indeed, it would. And that was another opposition, is that it would lead to a bunch of spurious lawsuits brought by people like yourself, Tom. I guess of all the regulations, and there are more than 90, this was the one to me where I was like, wow, I really don't see the public policy argument. I see it in some other areas, but I just don't see the public policy argument against the fiduciary rule. And I've tried.
Did the Trump administration issue a press release on this rule?
Yeah, they did. As part of their, and they said basically the argument that the industry, the financial advising industry, has made in favor or against the fiduciary rule is it would limit the options that Americans have in the financial products they can buy, which it absolutely does not do. It says that you have to state your conflicts, you have to state what commissions you're getting, and you have to act in the best interest of your client. I don't know. It's sort of like lawyers saying, if you require us to be fiduciaries, it'll limit the quality of the legal advice we give our clients. Because, now you're requiring us to give legal advice. I mean, it just doesn't make any sense. AJ, you were talking about like a wrap up here on everything we know about the regulations that the Trump administration has killed thus far. I think the wrap up is I hate to have it be so negative, but I think the wrap up is that regulated industries are going to get pretty much exactly what they want when it comes from this administration, and a lot of those regulations, maybe even including the one saying you cannot defecate in the Library of Congress, exists to protect consumers and to protect individuals. And it's not like individuals are going to have a bunch of lobbyists that they can send to Washington on their behalf.
So I guess I have a lot of questions. I have a lot of questions about whether this is a good way for rulemaking to happen in the country, that the Congressional Review Act should be hanging over administrative agencies' heads. I have another question, which is basically, are there concerns that the Congressional Review Act violates something like the presentment clause?
What is the presentment clause again?
So the presentment clause is the clause in the Constitution that says that legislation has to pass both houses of Congress and has to be presented to the president to be signed. And so there have been some cases.
That's interesting.
I think there have been some cases. Let me double check hold on, I'm going to cut this out.
Okay. I'm going to go take a bathroom break.
It's warm in my office.
It's warm in my office too.
It's warm in everyone's office. This is what's wrong with capitalism.
What happened?
Okay, Richard's back. So the presentment clause, it says that the bills have to pass both houses of Congress and have to be presented to the president, whereupon the president has to either sign or veto it. And this is in the Constitution. And so there's not a lot of case law on this, but there is one case that it was super interesting, I thought. So the Immigration and Naturalization Service, INS v. Chadha. And the idea there was that the Attorney General...
Great law school case. I remember this case.
The Attorney General was supposed to make certain determinations on certain immigration actions, and Congress retained the power to provide for a legislative veto on Attorney General decisions. And any one house could veto an Attorney General action, and the Supreme Court said that the legislative veto in INS v. Chadha violates the presentment clause. And I imagine that the Congressional Review Act, because it's a joint resolution of both houses of Congress, and then it still has to be signed by the president, you could imagine that it probably doesn't violate the presentment clause, but it does sort of...
How would it violate the presentment clause? I mean, this seems... What's wrong with it, I guess?
It seems to comply with the Congressional Review Act seems to comply with INS v. Chadha, but it also it just sort of seems like it's a really weird way to go about for Congress to go about delegating powers to these agencies that it sort of claims has that it sort of claims has like particular expertise in the field. And I think the reason why these joint resolutions exist, because Congress could always just amend the statute, right? If Congress is going to go and get a bill out of both houses of Congress and get it signed by the president, instead of just a joint resolution disapproving of a regulation, they could just amend the statute to repeal the regulation, right? I mean, sometimes you would amend the statute to do whatever the opposite of the regulation is, and sometimes you can amend the statute just to say this regulation is repealed, this section of the Federal Register is repealed, or whatever, or the Code of Federal Regulations is repealed. But I think the reason why these congressional resolutions exist is because they're not subject to a filibuster, whereas normal acts of Congress are subject to a filibuster.
No, that's exactly why they're doing this.
So basically, the entire scheme exists so that there's this special type of bill that Congress doesn't have to subject to a filibuster. And that whole little fiction is probably constitutional, but we should all acknowledge to ourselves is totally bizarre.
Yeah, I think there's an interesting challenge here.
I mean, but like, is it like a good way to run a country, right? I guess that was like my deeper question.
No, definitely not. I mean, in my opinion, not, because you have a very deliberative process by which the rules are created, and then a simple act of a resolution of Congress it just doesn't. You hear Republicans talk a lot about why there isn't more business investment or why the economy isn't doing so well is because you don't have regulatory certainty. You hear about this a lot. You need regulatory certainty in order for a business to know what they're doing. And it makes a lot of sense, right? You need to know that the rules aren't going to constantly change on you. Well, this seems like the exact opposite of that.
So is there like a deeper point? Like, is this one of those, I mean, much like, say, the national security estate, is this one of those things that Congress sort of set up in when it thought people were higher minded, and now we've sort of turned over the keys to the Trump administration in a way that we sort of regret? Or is this actually are these just the vicissitudes of politics that sometimes one party's up, sometimes one party's down, and this is just the way it goes? Like,
I think that is what it is, AJ. I think it is politics, or the vicissitudes of politics, the elections have consequences thing. I think, as with many things, the speed and intensity of the consequences of an election are somewhat new this time around. The fact that like so many rules are getting repealed so quickly, the fact that new executive orders are being put in place again so quickly, it's more that I think the system assumes there's going to be some amount of deliberation, even if not actual bipartisanship. And that's the part of the system that I think Donald Trump is most interested in upsetting. And I think you can look at that in this behavior. You can look at it in terms of his foreign relations. I think you can, whether you like him or you don't, I think everybody can agree he's not acting in any type of deliberate manner.
That's sad.
Yeah.
Tom, should we talk about the Supreme Court?
This is our Supreme Court predictions, everything we know about the Supreme Court. And I have 3 cases for you guys. You guys ready?
Mm-hmm. Let's do it, dude.
So the first case is Packingham v. North Carolina.
Ooh, I'm taking Packingham. Reach it, where you at?
North Carolina is very clearly going to win this case.
All right, Tom, next one.
Okay. I'm writing down AJ Packingham. Reach it.
All right. So Packingham v. North Carolina.
North Carolina. Okay. All right. So North Carolina has a law that bars sex offenders from basically posting on Facebook. And the question in this case is that a violation of the First Amendment? And for background, Mr. Packingham, when he was 21 years old, was charged with the statutory rape of a 13-year-old, convicted of he was charged of the statutory rape of a 13-year-old, but he was convicted of a North Carolina law that makes it illegal to take indecent liberties with the minor. I mean, take that for whatever it's worth. There's another North Carolina law on the books that makes it a crime for a registered sex offender, which Mr. Packingham became when he was convicted of taking indecent liberties with the minor, to access a commercial social networking website when he knows that it allows minors on. And I mean, that's not the entire definition of a commercial social networking website, but that's one of the issues in the case. Mr. Packingham, what he did was posted about a speeding ticket, and here's what he posted. God is good. How about I got so much favor they dismissed the ticket before the court even started. No fine, no court costs, no nothing spent. Praise be to God. Wow, thanks Jesus. So there are two sort of interesting points. One is that this law has an unusual definition of social media, which excludes certain sites that are limited for only one activity. Like if all you can do on the site is go to a chat room, then it's not within this definition. So you wouldn't be convicted of this law. Or if all you can do is post pictures, then you wouldn't be convicted of this law. So
you can Instagram but not Facebook.
That seems kind of idiotic since...
Yeah, but if there's a chat room and posting pictures, then,
okay. 80 Peckingham. Richard?
Yeah, I think Peckingham is going to win this one. I think 80 as well.
Oh, or 9-0.
8 or 9-0.
Yeah, I guess so. Yeah.
Unanimous for Peckingham.
It really is an interesting case because, it led Kagan to ask the question, if do you have a constitutional right to Snapchat but not to Facebook? And then, Ginsburg raised this issue of, if they have a First Amendment right, do they also have a right to vote? Do they have a right to bear arms? Both of which are, laws on the books that strip felons. In fact, there's only 2 states that never strip the right of a felon to vote, for example. And of course, there are multiple states that have restrictions on what felons can possess a firearm.
So there are historians who say that restrictions on felons voting and possessing firearms were designed as restrictions on, in particular, African Americans. That African Americans are disproportionately subject to the criminal justice system, and it was a way of entrenching white supremacy. And it's sort of the reason why some of these restrictions are so long-standing is that they sort of come from an era when a lot of the laws were also fairly racist. So I think that Ginsburg is actually making a good point here. I have a question for Ruchit.
Yeah.
Because I think this case is so obviously unanimous for Packingham that for me the real question is the statute unconstitutionally broad or over vague, or is it a restriction on free speech? And the reason why I ask is that if they go for over breadth or vagueness, they have a way of avoiding touching the issue of what else should felons get to do.
That is interesting. I think it's unconstitutionally overbroad and vague. But I don't think the court's going to see it that way. I think they're actually going to stick with the. I think they're definitely going to stick with the First Amendment, and I think you will see in either concurrences, or maybe in the majority opinion itself, about some sort of veiled, maybe even thinly veiled reference to other restrictions on the rights of convicted felons.
So I think you have some speech absolutists. Like, I think you would say Ginsburg is an absolutist on free speech, and to a certain extent so are Kennedy and Roberts. And I can sort of imagine them doing this on the First Amendment, but I'm sort of wondering if a plurality or even a majority of the justices decide to do it for vagueness and don't reach the First Amendment question, and maybe even find that convenient as a way to avoid getting into the murkier issues. To give readers a little bit of background, there are two ways that you could say that this law is, well, there are more than two, but two in particular, you could say this law is constitutionally infirm. The first is that criminal statutes can't be overbroad. And the idea here, and they can't be vague. And the idea here is that people have to have some sort of reasonable understanding from the law about what actions are criminalized and which actions are not. And so someone out in the world, should be able to look at the statute and with some reasonable amount of background be able to understand what actions are prohibited or not prohibited. So the idea that there's like some websites out there that have one function but not one other function, and you can't go unless you know that minors are prohibited, but to what degree do you have to know that minors are prohibited? And sort of, well, on Instagram you can comment on others' photos, so is that just posting a picture, or is commenting on photos not doing the blah blah blah, right? Like you can imagine that this statute basically scoops up all internet activity depending on the reader, and so that sort of vagueness and overbreadth would make it impossible for the state to enforce the statute.
Well, can I throw a cog in the works?
Yes.
The question presented is limited to the First Amendment. So that means the Supreme Court, if they were to decide on vagueness or overbreadth, would have to get rebriefing and re-argument on that issue. So really they're limited to deciding whether under the First Amendment the law is permissible both facially and as applied.
So 2 thoughts on that. One, the court doesn't do it often, but the court actually has reached decisions that are not in the questions presented. It's like,
I would say they do that all the time.
But second, is there like some reason in the procedural history why overbreadth wasn't in the questions presented? Was it sort of like waived by accident in the appeals process? Like, was there like some like procedural deficiency why overbreadth wasn't pled?
Well, I think, and maybe you guys can correct me, but in order to have an overbreadth challenge, don't you have to have it as applied to you?
But this is as applied, isn't it? Like he actually has been charged.
Yeah, but what I mean is that under anybody's definition, the Facebook falls under the definition of social networks for the purposes of this law. The reason they were asking those questions about Snapchat and chat rooms is they were just playing out, okay, what are the ramifications of saying this is or is not a violation of the First Amendment.
Interesting. I don't know. I'm gonna stick with unanimous for Packingham. Tom, what's your vote?
I'm going to disagree with you guys and go 7-1 Packingham.
Whoa, who's the one?
Well, either Alito or Thomas. Probably Thomas.
I would say it'll be Alito.
Interesting. Okay. What's the next case?
The next case is an arbitration case. The Supreme Court of Kentucky here refused to enforce the parties' arbitration agreements because it held that when attorneys in fact who sign agreements lack authority to enter into those arbitration agreements despite having a broad power of attorney, if the power of attorney contract doesn't expressly include the right to enter into arbitration agreements, right? So just as stepping back and background, you have the right to have an attorney in fact, an attorney who has the right to get into agreements on your behalf, do sort of, take legal actions on your behalf. And a lot of times if you're in a nursing home, or maybe not a lot of times, but sometimes if you're in a nursing home, you need someone who can take charge of your legal affairs. And so you'll sign a contract with that person, giving that person the authority to make legal decisions on your behalf. And in this case, the people in the nursing home signed an agreement with some people, actually not attorneys, with some people, giving them the power of attorney over their lives, giving them the power to enter into contracts, do other legal, make other legal decisions on their behalf. And what the Supreme Court of Kentucky said is, well, you can do that, but in order for those people who have your power of attorney to get into contracts that have arbitration clauses, they have to expressly tell you in the contract that you originally signed that you're giving them the right to enter into arbitration contracts, because that's but what you're doing when you enter into an arbitration agreement is waiving and this is a quote from the Kentucky Supreme Court, a divine God-given right to a jury trial. Can't say disagree with that in any way, shape, or form.
Which God?
Any God. Every God. every god.
Tom, how ready are you to move to Kentucky?
Well, Kentucky under the ACA has fared really well with health insurance coverage, so that's a positive. I hear the Appalachian Mountains are beautiful, so another positive. Yeah.
Bluegrass.
Yeah. So the way this case comes before the Supreme Court is that...
Do they do barbecue? They have barbecue, I think.
I think Texas barbecue is probably better, but everyone write AJ about
for sure.
that.
Don't. I don't eat pork. So there's no barbecue but Texas barbecue. That
I don't eat meat.
Yeah, neither do I. But I like barbecue sauce.
Some of those sauces have meat, Rooch.
I mean, I read the ingredients on the bottle, okay. Tom. So.
Okay, anyway, so the way that this case gets before the Supreme Court is there's this law called the Federal Arbitration Act that basically favors arbitration agreements and says, look, arbitration agreements are going to be valid, irrevocable, and enforceable, and this is a quote from the law, save upon grounds as exist at law or equity in the revocation of any contract. So what that's basically saying is, look, if the reason you're objecting to an arbitration agreement is just a general rule of contract, right? Like, let's say I held a gun to AJ's head and made him sign a contract that has an arbitration clause in it. Well, that contract is going to be illegal, regardless of whether there's an arbitration clause in it or not, right?
So I think I get it. So the federal statute imports basic agency principle law, right? So there's an area of law about agency and principles, and the idea here is that principals can delegate to agents the authority to take actions on their behalf, including contracts. And there's a whole area of law that deals with the agents and principals. And the federal statute imports whatever the agent principle laws are in whatever the respective jurisdiction is. And the question here is, in Kentucky, did these agents have the authority to enter into arbitration clauses?
No, not exactly. So in Kentucky, the Federal Arbitration Act basically it preempts any law that makes a contract invalid, except for those laws that are generally applicable, right? Like, so I'm holding a gun to AJ's head and making AJ sign a contract. That's going to be a law that applies to an arbitration contract just as equally to any other contract, right? So the question here, the Kentucky has this rule that says, look, if you're going to give power of attorney to someone else, so if I'm going to sign my power of attorney to AJ, and if AJ is going to have the power to enter into arbitration agreements on my behalf, AJ has to disclose that power to me in writing. So that's the Kentucky state rule. The question is whether the Federal Arbitration Act preempts that Kentucky state rule, because it's not a rule that applies to any contract, right? It's a rule that only applies to these arbitration contracts. So that's sort of the general argument on the arbitration side.
It's a rule that applies to all agent principal relationships.
Yes, and that's the flip side of the argument.
Yeah, I'm gonna go with what so the nursing centers are the bad and the clerks are the old people.
Yeah,
I'm gonna go with the clerks. I'm gonna say 5. This is so hard because I don't know if there are 8 or 9 justices.
I think we can just pretend like 8 is the max right now, and then
Okay, I'm gonna say 5-3 to clerks.
Okay, reach it.
I am going to say the opposite, so I hate the Federal Arbitration Act. I hate arbitration clauses. I think they're the worst thing that's happened to consumers, maybe ever, but really in a long time. And here, I think the other point to note about the Arbitration Act is that preemption doctrine, as it relates to the Arbitration Act, has been very, very broad. And so courts have ruled in the past that the Federal Arbitration Act basically has something that's considered field preemption. So it's the most expansive type of preemption you can get, effectively meaning that, when you have a federal law, if you have something that kind of even remotely interferes with federal law, with the Federal Arbitration Act, it's going to be preempted. And so Scalia started this in many ways, but another reason to dislike Scalia, I guess. But Kindred, it's going to be Kindred Nursing Center, so they're going to win. I'm sad to say.
What's your vote count?
I'm going to say 5-3.
Okay. Well, Richard, I'm generally in agreement with you. I do think at least 5-3 Kindred is going to win, just based on the history of the Supreme Court being very protective of the Federal Arbitration Act.
I mean,
All right.
They just love that thing. They love that thing more than the NRA loves guns, you know?
So shall we go on to the third case?
Yeah, let's do it.
So this is Hernandez v. Mesa, and
I think that's Mesa, Tom.
Mesa, M-E-S-A. Sure, Mesa. Hernandez v. Mesa. Yeah. The question in Hernandez v. Mesa is, does the Fourth Amendment prohibition on the unjustified use of deadly force apply when a Customs and Border Protection officer standing on American soil shoots...
Oh, dang, I read about this in the news.
...an individual standing on Mexican soil? So
this case is crazy. That guy's this whole thing is super sad and super crazy.
Yeah. So this is
somebody shot. So a Customs and Border Patrol officer shot someone across the border. Is that what happened?
Yeah, basically. So he was standing on American soil. There was a 15-year-old child playing in a culvert in El Paso, Texas, between El Paso, Texas and Juarez, Mexico, and he shot that child, hit him in the head, and killed him. Now there's some conflicting stories as to what exactly happened. The child, Hernandez's parents, said, look, this was a kid. He was playing with his friends in this culvert between El Paso and Juarez. What they were doing was they were daring each other to run up to the culvert's northernmost incline, touch the U.S. fence, and then run back. And then as Hernandez was running away from the fence back down to Juarez, on the Mexican side of the border, the officer Mesa fired at him from about 60 feet away on the U.S. side of the border, and then he hit him in the head, and he dies on contact. Now, Officer Mesa says, well, look, I was justified in my use of force because Hernandez and these other kids were throwing rocks at him and refusing his verbal commands to stop. There was a DOJ investigation which concludes that, the shooting took place while alien smugglers, I'm using scare quotes here, including Hernandez, unsuccessfully attempted an illegal border crossing and began to hurl rocks from close range at Agent Mesa while he was attempting to detain a suspect. The larger point is, that there's a factual dispute, and, who knows what the facts are going to actually show if it were to go to trial. The question before the Supreme Court is whether it can actually go to trial or not, whether whether there's a bar against a lawsuit like this because this 15-year-old kid was standing on Mexican ground, Mexican soil, when he was shot by this officer.
What exactly does the law say that would authorize the action?
So there are a couple of ways he can assert this claim, right? It would either be in the qualified immunity context or under the Bivens context.
Okay.
Basically,
I think the Fourth Amendment applies to things that the government does. Right. I mean, it protects people from the government, but for the Fourth Amendment to have for the Fourth Amendment to truly be meaningful, it would have to apply to things that the government does. And you could say it's wherever it is that the government does it, but at the very least, if the government is doing it in the United States. So if the actionable conduct occurred in the United States, right, then the Fourth Amendment would govern that conduct, right? And we've got all sorts of applications of the Bill of Rights to areas abroad, right? There are 14th Amendment rights abroad, there are Fifth Amendment rights abroad, et cetera, and those Fifth Amendment rights apply not only to U.S. citizens but to non-citizens that are in U.S. custody or whatever. Anyway, the Fourth Amendment, I mean, it can't just be that the government can ship you to the border and then once you're in the border shoot you at the head, right? like, oh, if I'm on one side of the border and you're the other side of the border, I can shoot you in the head and there's nothing you can do about it. Like the Fourth Amendment, to be meaningful, if the United States government is going to maintain these operations in all of these countries, if we're really going to have ground troops in Syria, if we're really going to have Guantanamo Bay, for the Fourth Amendment to mean what it should mean to the fullest extent of the law, it has to apply to this case.
I think, can I make a prediction as it relates to this case?
Sure. Well, before you do, let me push back on that a little bit, AJ. One of the issues that was raised in oral arguments of this case was, well, if, this lawsuit is allowed, does that mean folks who are in war-torn countries who have had a drone strike kill their family members, because presumably maybe not presumably, but assuming that drone strike were ordered from within the United States borders or piloted within the United States borders, would that allow a lawsuit to go forward against the United States under the Fourth Amendment?
Two things on that. One, yes. But two, you could imagine the court crafting some sort of fiction about how drone operations are acts of war and the executive has these sort of enhanced powers in the conduct of the military. But border security is a law enforcement operation. It is not a military operation.
For now.
Well, but as much as we militarize the border, it will always fundamentally be a law enforcement activity. And if the Fourth Amendment means anything, it has to apply to law enforcement activities wherever they may be. You can't start carving out exceptions where law enforcement doesn't have to follow the Fourth Amendment in these very specific circumstances. Like maybe the military is or is this other thing, and maybe even the CIA is or is this other thing, but the police, all of the law enforcement agencies in the country, like the police, right? Like the I don't know. To me, I mean, I don't know. I think the fact that the court took the case is a really good sign, right? This sort of seems like this is not the sort of case where the officer won in the court below, right? So it's the Hernandez family that are appealing, and usually when the Supreme Court takes a case, it's much more common to reverse the court below than to affirm the court below. And so to me, the idea that an 8-0 court sort of in a moment of indecision in the country even wants to take this case, to me it's a sign that they want to reverse the court below, because to take this case, to wade into this issue would be a totally unnecessary own goal for the court if they're just going to affirm that the Fourth Amendment doesn't mean the things that Americans think it ought to mean. So I don't know. I don't think it's going to be unanimous. I think it's going to be
no,
you can't stop me.
All right. Okay.
All right, stop.
So you're absolutely right that it was the lower court sided with the Officer Mesa in the court below. The lower court was the Fifth Circuit, and they wrote it was an en banc opinion, unanimous, written by Judge Stewart, the Chief Judge Stewart of the Fifth Circuit, who held that the plaintiffs failed to allege a violation of the Fourth Amendment and that the Fifth Amendment right asserted by the plaintiffs was not clearly established at the time of the complained incident.
Oh, this is like a qualified immunity issue, right?
Well, it's both, right? Like they're alleging a Fourth Amendment violation, right? And qualified immunity applies to the Fifth Amendment right.
Okay, I'm going to say 6-2 for Hernandez, but I think that it's sort of not over there. They're going to remand it for a trial, and somehow during the course of the trial, the courts will find a way to let the government win. But I think like deep down, there's going to be this like principled stand that if the Fourth Amendment has to mean something, it has to apply here. But then actually Hernandez isn't actually going to get anything from the courts in the end. But I do think that there'll be this sort of like piety to the Fourth Amendment expressed here.
I think my vote is like 5-3 against the Hernandez family.
So Mesa?
Yeah, for Mesa. And I think the way this thing is going to go, if AJ is right, and there is a majority for the Hernandez family, I think this will be the first occasion on which Donald Trump directly attacks the Supreme Court.
Ooh. Wow. You have to add that to the predictions page, Tom.
Yeah, I think that is he is going to attack the court for siding against I mean, if not to go too far down, but if Trump's goal is indeed to become a dictator, and part of that would require destroying the credibility of everyone and every institution that is not Donald Trump, then this would be an opportunity for him to attack the court and to begin the process of destroying its credibility.
So I tend to agree with AJ that I think that in the end the court will side with Hernandez, but I think it's going to be a 5-3. I think you're going to see the conservative justices side with Mesa, and I think you're going to see Kennedy flip to the liberal justices and side with Hernandez, because I think just on the facts alone, you know, it's just very sad what happened. You know, you have a 15-year-old kid that shot, and to say that 15-year-old kid has no remedy, I think is going to tug at Kennedy's heartstrings.
All right, you want to do sidebar?
Yeah, sure. Let's do sidebar. Sidebar is the.
Oh, okay. I want to go first.
AJ, you want to go first?
I want to go first.
Okay,
oh,
you go
really
first.
Good. Oh, I got a good one.
Okay, so Pete Souza was the White House photographer during all 8 years of the Obama administration. Rest in peace.
He's still alive.
And
yeah, Pete's alive, right? Is Barack Obama alive? He's still alive, right?
Rest in peace, our country.
Oh, okay.
So he has an Instagram, and his Instagram is off the chain.
Agreed.
He's throwing tons of shade at Donald Trump in a way
shade
that is extremely good.
And before you go on, a little factoid about Pete Souza is that he was Reagan's White House photographer as well.
Wow.
I
didn't know that.
I didn't know that either.
So so Pete Souza has all of these photos of Obama that he's taken, and every once in a while he'll throw one up on his Instagram, and then the caption underneath is just sort of like the photo itself is sort of innocuous. It's just, there's one of Obama sitting in the Situation Room, and then what he says is, Obama meets in the Situation Room for the first time with his national security team on January 23rd, 2009. During 8 years, I documented more than 100 meetings in the Situation Room. Not sure if it gets much use now.
The other thing that I'll say about his account is I find those situations are like express shade that he throws, right? Like, but sometimes what he'll do is like, so when Trump is meeting with Angela Merkel, for example.
Oh yeah, I thought this was great.
He'll just post a picture of Obama hugging Merkel.
Or by request, President Obama with German Chancellor Angela Merkel, the G20 summit.
Yeah.
It's just. He just loves doing that stuff.
He's funny.
It is pretty cool.
All right.
Richard?
Someone else go.
Guys, I heard about gravitational waves.
Tell us about gravitational
this past
waves.
Week with a physicist professor at Columbia called Brian Greene. It was pretty cool. I can't really explain it, but I recommend everyone watch the YouTube video on gravitational waves. If you Google gravitational...
Can you provide us a link in the show notes at heartlanded.com?
Yeah, sure. We really should have Brian Greene on the show.
He made his fame by writing that book called The Elegant Universe about string theory.
Yeah. Yeah. I got one of his books. I got his Hidden Universe book. But yeah, but what about that?
Well, he was like one of the I guess the people that popularized string theory.
I got a chance to ask him what is string theory. It was pretty funny.
When? Where?
Well, he was at this conference that I was at. That's where I heard about it. That's where I heard his story and his stuff on gravitational waves. So, and then I talked to him for like 10 minutes after he spoke.
Well, tell us about that. That sounds more interesting than gravitational waves.
Well, so I told him. So one of the things I told him was I was like, I don't know anything about physics. And I was like, which is really cool because I could like double my knowledge in like 2 weeks. And he said to me, "Man, I envy you." I was like, "Yeah, it is pretty awesome being able to double your knowledge every 2 weeks for like, I guess weeks or years on end because you know so little." So, but he was a cool dude. Anyway, gravitational waves.
What did Professor Greene tell you about gravitational waves?
So like I said, I didn't understand everything he said, and it's more of a deficit in my understanding than his explanation. But he was basically explaining this recent proof of Einstein's theory of relativity that happened, I think, late last year. And so he was talking about how one of Einstein's theories was, I guess it was about gravity, and he was unable to sort of he was able to sort of describe how gravity worked, but unable to prove the way that it actually worked. And so the way that these scientists proved the way that it worked, or Einstein's theory on how it worked, was they were able to notice the effect of gravity on light. And the only way they were able to prove that was by building like a 4-kilometer long tunnel that was like completely, I guess, like it was away from where you would have an earthquake or any type of sort of call it natural. And by natural, I mean like interference from things happening on Earth itself, let's say. And so they built like a 4-kilometer long tunnel that intersected with another 4-kilometer long tunnel with light kind of bouncing around in that tunnel. And so they were able to notice the rippling of gravity and its effect based on just sort of a slight change that happened, a gravitational tug or push on that particle of light.
Interesting.
And I'm not doing a very good job of describing it. But
so, I mean, can I add a couple of things? So
yes, please.
This is really cool, right? Like, basically Einstein predicted, so we have Newton who originally came up with these laws of gravity, right? Saying that, look, the same force that applies to an apple that falls from an apple tree applies to the motion of planets around our sun, right? Einstein came around and basically said, that Newton guy was great, right? But I can refine his theories of gravity just a little bit and be a little bit more accurate. And for the vast 99.9% of the things that humans do, Newton's laws of gravity are great. You can use his equations. But if you're going to travel through space, you're going to need my rules of gravity. You're going to need my equations in order to determine how gravity works. And for the most part, when he put out these theories of gravity, folks were like, yeah, Einstein, you did a good job, but there's no way to prove it until you were able to actually show the bending of light. So there was this experiment where they proved, and I think this is what really made Einstein famous, was they proved how light curved around the sun. And by showing that light was curving around the sun, you were basically able to prove what Einstein was saying about gravity and the effects of gravity on things like light, were true, were correct, right? So that's sort of one of the things that made Einstein so famous, his ability to predict these things. And I haven't read much about these the recent experiments on gravitational waves, but it sounds interesting.
Yeah, this was like the big discovery that happened last year. That's what he was sort of talking about, which some people may have seen in the news.
Okay, so my sidebar is about South by Southwest. As many folks in Austin know, South by Southwest is a thing, and it's a thing that's happening in Austin right now. During this conference at South by, the CIA demonstrated, and Ars Technica had an article on this, about some of the board games that it uses to train its personnel, its officers. And I thought this was, the three of us are sort of board game aficionados. We enjoy a good board game from time to time, which we need to have, by the way. Maybe we can have an episode where we record ourselves playing a board game. I think that'd be fun. Maybe not, I don't know.
Yeah. Well, I think we should intersperse it with enough ohms so that our listeners can either get meditative peace or they can be interested in us playing board games.
But so the CIA basically makes up their own board games in order to train their officers. So like one board game they had was called Collection, which is like the popular board game Pandemic. Basically, a group of players must work together to resolve major crises around the globe. And these players, you got to have at least 3 players, which maybe we could play if we had this game. CIA, if you're listening, I know you are, send us a copy of this game. But, the three players fill the roles of political analyst, military analyst, and economic analyst. And, these crises pop up, and you basically have to prevent a crisis from going nuclear on this fire scale they have. Another board game that they invented is called Kingpin, and it's a game about finding a fugitive from justice who will, if not found sooner than later, will likely do harm to innocent people or harm U.S. interests. And this person is a well-armed, well-defended, and well-protected bad guy, and they were talking about how some of these board games even helped them find El Chapo, the Mexican drug kingpin.
So I read an article about this.
Was it on Ars Technica?
And yeah, I think so. The thing that really blew my mind is that these CIA board games are grossly unfair. There's just there's someone whose job it is to just throw cards in the middle of people playing. There's someone who's just your source was bad, you blew it. Something bad happened. It just your cell phone stopped working, and the gross unfairness of these board games I thought was really interesting as a team building.
Yeah, I think that is part of what makes it fun, right? They're supposed to be really hard. You lose more often than you win. And you have to really work together in order to win.
So if the CIA is willing to sponsor one episode, this is an offer, CIA. We are willing to play your board games on the air, record it, and tell people what we really think, which could be good for your PR. If you care about such things as you battle President Trump for institutional credibility.
CIA, you want to sponsor the show, hit me up. My Twitter handle is @AJ Small, although you probably already knew that.
You can also find it.
You can reach us at heartlanded.com.
Heartlanded.com. Yo, CIA, check the show notes. CIA, check the show notes. Look at the show notes.
Guys, can we link to the CIA in our show notes?
We should link to the wrong CIA, Tom.
CIA.com, not CIA.gov.
Yeah, exactly. And if that leads to a porn site, so be it.
This is how we get kicked off iTunes, guys.
Okay, good point. Let's not talk about that. AJ, check the show notes. Can you delete this portion and check the show notes?
CIA, check the show notes. All right, let's call it. I gotta go.
And then I had a bunch of Cuban Uber and taxi drivers in Miami. And one of the guys was a recent immigrant. He had just immigrated from Cuba 2 years ago. And he said, also very politely, anyone that doesn't understand that this is a country of immigrants is an idiot. But he was very polite about it. And he was telling me about how he was saving up so he could become a truck driver. And I was like, wow, that sounds really hard being a truck driver. Are you sure you want to do that? And he said, oh, yeah, it'll definitely be really hard. But if I do that for 2 or 3 years, I can save up enough to buy my own truck. And then I can earn more money and I can, have flexibility and, live a better life. So,
man, that's the American dream.
That's just American dream. Those
are the hollow aspirations that capitalism foists on us instead of, our sort of our base instinct to just find fulfillment in the self. I'm getting some good ohms for the after show.